Okay, let's jump right in. Today we're giving you the quick guide to contract law essentials. Basically, what turns a simple promise into something legally enforceable.
Exactly. It's the core question, isn't it?
Yeah.
Fundamentally, a contract is, well, the definition is an agreement enforceable by law.
And enforceable by law, so not every agreement counts.
Not at all. Many agreements happen, but they don't cross that threshold into being a contract. There's a vital first step.
Which is the intention part, right? You have to actually mean for it to be legally serious.
Precisely. Intention to create legal relations. Think about everyday promises. You tell a friend you'll buy the next coffee. You don't expect them to sue you if you forget.
Makes sense. So the law needs to see that seriousness. Is there a famous example of this?
Oh, definitely.
Yeah.
The classic case is Balfour v. Balfour. A husband promised his wife a monthly payment while he worked abroad. But when things went sour, the court said essentially, look, this was a domestic arrangement. When they made that promise, neither of them probably thought, this is something we could go to court over. No intention, no contract.
So intention is the gatekeeper. If we pass that, what's next? That meeting of the minds thing?
Yes, mutual assent. That's the offer and the acceptance. Someone makes an offer, someone else accepts it. Sounds simple, but...
There's always a but, isn't there?
Well, traditionally, yes. The law used to demand what's called the mirror image rule. Meaning the acceptance had to be exactly the same as the offer. Any little change, even a tiny one, wasn't an acceptance. It was considered a rejection and a new offer, a counteroffer.
Wow, that sounds really impractical for modern business.
Yeah.
Like when companies send forms back and forth, the battle of the forms.
You hit it exactly, and the law has adapted, especially in places using the Uniform Commercial Code, the UCC, mainly for goods in the U.S. It's more flexible. The UCC often allows a contract to form, even if the acceptance has slightly different or additional terms, as long as they don't fundamentally change the deal. It acknowledges commercial reality.
Okay, so we have intention, we have agreement. What else fuels this? Consideration, right? The exchange.
That's it. Consideration is the bargain element. What each side gives up or promises to give up. It's the price for the other person's promise.
Does that have to be like a fair price, equal value?
That's where it gets interesting. The general legal principle is that consideration need not be adequate.
Meaning?
Courts usually don't care if you made a good deal or a bad one. They just want to see if there was an exchange, something bargained for by both sides. Even something tiny, a peppercorn, can be enough.
Just the existence of the swap matters, not the fairness.
Largely, yes. But, different legal systems can have nuances. Take the Indian Contract Act, for example. It has a slightly different take. Under the ICA, consideration doesn't have to come from the person receiving the promise. It can move from the promisee or any other person.
So a third party could provide the value.
Exactly. The case Chennai v. Ramaya established this. It's a notable difference from, say, traditional English common law.
Interesting. Okay, let's shift here slightly. What about protecting people? Like, who can even make a legally binding contract?
Yeah.
Capacity.
Right. Capacity is crucial. It's about whether someone has the legal ability to enter into a contract. The main focus here is often on minors.
People under 18, usually.
Depending on the jurisdiction, yes. And some legal systems are very protective. In India, for instance, the Mahori Bibi case set a strong precedent.
What did it say?
It established that a contract with a minor isn't just voidable, it's void ab initio.
Meaning void from the very start, like it never existed legally.
Precisely. It's a very strong protection. Though there's usually an exception for necessaries, things like food, shelter, basic education. A minor might still be liable for those, often paid from their property, not personally.
Okay, so that brings up a key distinction for anyone in business listening. The difference between a void contract and a voidable contract.
Yes, that's vital. A void contract, like the one with a minor in the Mahori Bibi context, is basically a legal nullity from day one. It lacks essential elements.
And voidable.
A voidable contract starts as valid, but one party has the option to cancel or rescind it because their consent wasn't genuine. It wasn't free.
How could consent not be free?
Things like coercion, being forced into it,
Right.
or fraud, being tricked, or undue influence where someone in a position of power unfairly pressures the other party. The victim can choose to end the contract.
So, wrapping this up, the big takeaway for anyone drafting agreements seems to be clarity and legality are paramount.
Absolutely. You need certainty in your terms. Ambiguity is risky. And, of course, the purpose of the contract must be legal. Anything illegal or against public policy.
Like an unreasonable non-compete clause, maybe?
That could be an example, yes. Those things can make an otherwise valid-looking agreement completely unenforceable. It shows there's a limit to the freedom to contract. The state still oversees things.
Which leads to a final thought, maybe.
Well, it makes you think, doesn't it? Even if you have agreement, consideration, capacity, the law can still step in if the deal is impossible or fundamentally clashes with society's values, with public policy. So here's something to chew on. What common business practices or contract terms seem perfectly normal today, but might 10 or 20 years down the line be seen as violating some future standard of public policy? Things change.